2 steps up, 1 step back. Let's talk about the trial date that was just set in Steve Bannon's criminal case for contempt of Congress. Because justice matters. Hey all, Glenn Kirshner here. So Judge Carl Nichols just set Steve Bannon's trial date in his contempt of Congress case. Here's how NBC News reported it. Judge sets July date for Steve Bannon's contempt of Congress trial. And that article begins, a federal judge set a July trial date for former Trump aide Steve Bannon, charged with 2 counts of contempt of Congress for refusing to respond to a subpoena for his testimony from the House committee investigating the January 6 riot at the U.S. Capitol. The Justice Department urged the judge to schedule the trial for April. Prosecutors said they would need only 1 day to present testimony. Bannon's lawyers said the case presents novel issues. They said the trial should not begin until mid-October and would likely take at least 10 days. U.S. District Court Judge Carl Nichols said the government wanted to move, quote, at light speed in a case that may present complicated issues, but he also said, quote, we don't need 10 months to do this. He scheduled the trial to begin July 18 and set aside 2 weeks on the calendar. Now, Judge Nichols' decision to set this trial in July, which I'll talk about in a minute, prompted what was probably one of my favorite characterizations of the hearing. This from BuzzFeed's senior justice reporter, Zoe Tillman. She tweeted, "Mark your calendars. Judge Nichols set Steve Bannon's trial to begin July 18, allowing for 2 weeks. A real Goldilocks moment. The judge said he believed that Bannon's proposed October trial was too slow, but the government's April trial date was too soon." A real Goldilocks moment. I guess Judge Nichols, a Trump appointee, didn't want the justice porridge to be served up too hot or too cold. I'd like to see it served blistering hot. Maybe that's just me. It's probably you too. But the reasons offered by Bannon's lawyers as to why they wanted this trial pushed out almost a year into the future, those reasons ranged from weak to absurd. Again, reporter Zoe Tillman cataloged some of those reasons in today's court hearing. Regarding why Bannon needs a lot of time, lawyer David Schoen says their intended defense strategy potentially includes arguing grand jury wasn't properly instructed regarding Bannon relying on advice of counsel. The January 6th committee lacks valid legislative purpose and selective prosecution. So let's take those in order. The grand jury wasn't properly instructed by the prosecutors. Trust me, friends, Bannon's lawyers will not get to pierce the veil of grand jury secrecy by making those kinds of absurd, unfounded allegations. That will be rejected by the judge. The January 6th committee lacks a valid legislative purpose. That's wrong. In fact, it's already been rejected by other judges, Judge Tanya Chutkan, for instance. So that will be rejected by the judge. And then let's turn to what has got to be my favorite defense assertion, selective prosecution. So can we go to Team Justice Law School for just a minute and talk about selective prosecution? That is essentially Steve Bannon saying, sure, I committed crimes, including contempt of Congress, but other Donald Trump criminal associates committed crimes too, and they're not being prosecuted. Tain't fair. I'm being prosecuted. They're not. That violates my due process rights because I'm being selectively prosecuted. A couple of observations about that. First of all, selective prosecution is extremely difficult to prove. In fact, my favorite quote from the Supreme Court about selective prosecution, quote, "A selective prosecution claim is a rara avis." That would be a rare bird. Cute little semantic flourish there from the Supreme Court. Very difficult to prove. It's been attempted. One of the most famous cases involving selective prosecution was back during the Vietnam War, during the draft. There were approximately 674,000 people who failed or declined to register for the draft. 674 non-registrants. You know how many the federal government prosecuted? 13. And those 13 made claims of selective prosecution, due process violation, and the Supreme Court rejected those claims. It is a very hard thing to prove, selective prosecution. So that will be rejected. It really is a frivolous claim by Steve Bannon's lawyers. But here's the other thing. Steve Bannon may very soon be in good company in the criminal contempt of Congress club for a couple of reasons. One, it looks like Jeffrey Clark may be heading in that direction. And here is the reporting from literally just a few minutes ago from our friend Scott McFarlane. Alert, U.S. House Select Committee says if Mark Meadows doesn't show for tomorrow's scheduled deposition, the Select Committee will be left with no choice but to advance contempt proceedings and recommend that the body in which Meadows once served refer him for criminal prosecution. But let's finish with this, friends. I was disappointed when Judge Nichols split the trial date, baby. Right? The prosecutor said, time is of the essence. On behalf of the American people, we want an April trial date. The defense, of course, said, time is not of the essence. Let's push it way off to mid-October. And the judge split the difference. Not unusual. In fact, that's pretty much judging 101. But these are not normal times. And these are not normal criminal cases. So I do feel like even though we took 2 steps forward when the Department of Justice indicted Steve Bannon for contempt of Congress, today the judge took 1 step back on the justice front. And justice matters. Friends, as always, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.